Welcome to our channel. Today we will explore a fascinating and complex topic that touches every aspect of our social and professional life: the relationship between obligations and conflicts of interest. Let's discover how these two realities intertwine and influence our daily interactions. Before delving into this exciting topic, I invite you to subscribe to the channel and activate the bell so as not to miss any of our detailed analyses. Ready? Let's go! Obligations and conflicts of interest between people are intrinsically related in the field of interpersonal relationships, both in the legal and social and economic contexts. Here we will analyze how these two notions interconnect and influence interactions between individuals or entities. Definition of obligations. Obligations are legal or moral duties that one person, debtor, has towards another, creditor. These can arise from law, contracts, torts, or even from the unilateral will of the parties. In the context of bonds, the debtor is expected to comply with a certain behavior, which may be to deliver something, perform a service, or refrain from doing something. Definition of conflict of interest. A conflict of interest occurs when a person or entity has two or more divergent interests and attention to one interest could harm or adversely affect the other. Generally, a conflict of interest calls into question an individual or entity's ability to make impartial decisions and act in the best interests of all parties involved. Impact of bonds on conflicts of interest. Bonds can be a source of conflicts of interest, especially when a person has a duty to act for the benefit of another but, at the same time, has personal or professional interests that could interfere with that duty. For example, in a professional setting, a financial advisor may have an obligation to recommend products that are in the best interests of his client, but at the same time he may be tempted to promote products that generate higher commissions. To manage conflicts of interest, it is essential to establish and respect clear rules governing the obligations between the parties. This may include disclosing any personal interests that could influence decisions, recusing yourself from decision-making in the event of a direct conflict, or even reassigning certain responsibilities to ensure that obligations are met fairly and equitably. The relationship between obligations and conflicts of interest also highlights the importance of ethics and transparency in human interactions. Acting ethically involves recognizing and appropriately managing conflicts of interest to meet obligations in a way that preserves trust and minimizes harm to the parties involved. In conclusion, obligations and conflicts of interest are deeply intertwined in the dynamics of relationships between people and entities. How these aspects are managed can have a significant impact on the integrity and effectiveness of social, professional, and legal interactions. The key to adequately managing the relationship between obligations and conflicts of interest lies in the definition of clear rules, the practice of transparency, and the ethical commitment in all actions. Understanding obligations is essential to being able to harmonize conflicts of interest between the parties involved in any relationship, be it legal, commercial, professional, or personal. This understanding helps establish a framework within which conflicts can be managed and resolved in a fair and equitable manner. Below we explain why it is important to understand bonds. 1. Understanding obligations helps clearly define the rights and duties of each party. This is critical to avoid misunderstandings and set realistic expectations about what each party should do or refrain from doing. 2. A thorough understanding of obligations allows you to identify cases where conflicts of interest may arise. By recognizing these potential areas of conflict, parties can take preventative measures to mitigate problems before they escalate. 3. When conflicts of interest inevitably arise, having a clear understanding of obligations provides a framework for resolving them. The parties can refer to their original obligations to guide the discussion towards a solution that respects the rights and duties of all. 4. Transparency in understanding and managing obligations strengthens trust between the parties. When each party knows that the other is acting within a framework of agreed-upon obligations, a more harmonious collaboration is facilitated. 5. Understand and act on obligations encourages ethical decision-making. This is particularly relevant in situations where conflicts of interest could cause a party to act contrary to its duties. 6. Understanding obligations also provides a basis for negotiating adjustments or modifications when circumstances change. This is critical to adapt to new information or contexts that may affect how conflicts of interest are perceived or managed. 7. In many contexts, obligations are defined by law or specific regulations. Understanding these obligations is essential to ensuring that any resolution of conflicts of interest remains within legal and regulatory boundaries. Understanding obligations is a crucial step in harmonizing conflicts of interest, as it provides the tools needed to prevent, identify, and resolve conflicts effectively. By establishing a clear framework of rights and obligations, the parties can collaborate more effectively, maintaining relationships based on trust, transparency, and mutual respect. This approach not only helps resolve conflicts when they arise, but also helps prevent their occurrence by aligning the interests of the parties towards common goals and respecting mutual obligations. But let's go into more detail. What are bonds specifically? Think of bonds as different types of promises we normally make in life. For example, if I promise to lend you my favorite book, we would be under an obligation to give. If I commit to helping you study for the physics exam, I would take on the obligation to do. And if I told you that I won't reveal the surprise ending of that book, we would have a don't obligation there. Now, think of these obligations as two sides of a coin. On the one hand, the person receiving the promise, let's call him the creditor, has a credit, that is, something to aspire to. On the other hand, the person who makes the promise, the debtor, has a debt, that is, an obligation to perform. In this world of promises and obligations, there are some clear rules. For example, not all promises affect other people when the promiser dies. Then there are some very personal promises, such as the promise to be godfather at baptism. That promise cannot be passed on to your heirs, it is something exclusively yours. Another important thing is that every promise must have a reason for being, that is, something that justifies it. You can't just say, I owe you ice cream, for no reason. However, even if you don't say why you owe me ice cream, it is assumed that there is a valid reason, unless I can prove otherwise. And here's an interesting twist. If the reason you gave for the promise is false, but there's actually another good reason behind it, the promise is still valid. But be careful, if the reason is something illegal or immoral, the promise is worth nothing. Obligations are like private agreements between people. They do not concern everyone, but only those directly involved and their successors, unless you have promised something to a third party. In this case, if the third party agrees, then he can ask you to keep your promise. Finally, these obligations have effects both for those who receive the promise and for those who make it. The creditor can take legal action to force you to comply, and the debtor, once his obligation has been fulfilled, can ask for it to be recognized that he no longer owes anything, or he can defend himself by assuming, for example, that the obligation is no longer valid for some legal reason. And this is how he turns the world of obligations, with promises, reasons, and rules that make everything work like clockwork. Obligations are an essential part of the functioning of society. To better understand, let's analyze the following key statements. Nature of bonds. Bonds are like commitments we make. They are responsibilities that we acquire towards other people. They can take different forms, such as promising to do something, giving something, or even refraining from doing something. For example, if you promise to return a borrowed book to your friend, this is an obligation. Origin of bonds. Bonds do not arise out of thin air. They always have a reason or cause behind them. For example, if you undertake to pay a debt, the cause of that obligation is the debt you have incurred. Rights and debts. When you take on an obligation, you are creating a bond between two parties. If you have the right to demand something from someone, this is called credit. For example, if someone owes you money, you have a claim against that person. On the other hand, if you have an obligation to do something, give something, or not do something, this is considered a debt. For example, if you have to deliver a report to your boss, that is an obligation. Relationship between rights and obligations. Every personal right entails a personal obligation. This means that if someone has the right to receive something, another person has the obligation to provide it to them. For example, if you are entitled to receive a salary for your work, your employer has an obligation to pay you. Cause of bonds. Every bond has an underlying cause. This means that behind every obligation there is a reason, whether it is an agreement, a legal act, or even a family relationship. For example, if you agree to take care of your younger brother, the cause of that obligation is the family relationship you share. Presumption of cause. Sometimes the cause of an obligation is not explicitly mentioned in the contract. However, it is presumed to exist unless the debtor proves otherwise. For example, if someone agrees to help you on a project, collaboration on the project is assumed to be the cause, unless they prove otherwise. False cause but valid obligation. When the cause expressed in an obligation is false, the obligation remains valid if it is based on another true cause. For example, if you promise to give someone a gift on their birthday, but it turns out that the date of birth you mentioned was wrong, the original cause may be false, but the real cause is still the desire to give a gift. Illegal obligations. If an obligation is based on an illicit cause, it has no legal effect. This means that if the agreement is contrary to law or public order, it will not be valid. In short, obligations are like the commitments we make in society, whether it is promising to do something, giving something, or refraining from doing something. They have an underlying cause, can arise from different situations, and must be legal and morally acceptable to be valid. They are an essential part of the functioning of relationships and agreements in our society. After this in-depth analysis, a natural reflection arises: how many times have we had to manage a conflict of interest in our lives? And how did we resolve the situation while maintaining ethical integrity and our obligations to others? Share your experience in the comments. Your contribution is precious to enrich the debate. Understanding the connection between obligations and conflicts of interest is essential not only to navigating the legal and professional world, but also to maintaining healthy and productive personal relationships. It is a delicate balance that requires transparency, ethics, and careful management of our responsibilities. If you liked the video and it gave you food for thought, leave a like and subscribe to the channel to support our work. Don't forget to share the video with anyone who might find the topic useful. Don't miss the next episode of this series on the relationship between obligations and conflicts of interest. See you soon.